Good afternoon, or actually, it's just about noon right now. Thank you for coming for the press conference at the Foreign Correspondents Club of Japan. My name is Teddy Jimbo. I chair a committee that organized the media event at this club. It's called the Professional Activities Committee, and I co-chair the committee, and also I run a internet news site called videonews.com, and I'm your moderator today. And we have a very distinguished speakers today. I think many of you will find his story very interesting. I think we should just go right to the speaker. Let me just give a brief introduction. The center of the table, second from my seat, my right, is Mr.村磯高志. It's actually not his real name. He does not wish to reveal his real name. He might tell you why, but anyway, so he will go by the name Mr.村磯高志, and he's a former secretary of issue Sugawara, who was a Meiji minister, and who has resigned as a minister, and also who has resigned as a member of the Diet after the disclosure that he had given money to his voters, and he was just recently indicted by the prosecutors. So he will talk about the transaction or the dialogue took place between his former boss, Mr. Sugawara, and himself. And the reason he decided to come out today is that his former boss's testimony and public and explanation to the public is not truthful. It's not what he actually had experienced, and he wants to get the record straight. So that's why he's here. And my immediate right is a kind of familiar face at this club, lawyer Nobuo Gohara, and he is the lawyer. He's the attorney for Mr. Muraiso. And so he will explain the sort of a legal framework and legal background of this case, and the significance, of Muraiso-san's, Mr. Muraiso's statement today. And the interpreter today is Seth Reams. So he'll be interpreting every Japanese sentences into English, and also when question is asked in English, he will translate it into Japanese so that the speakers do understand what the what questions are. So let's start we will start with Mr. Gohara, and then Mr. Muraiso will speak, and then we take questions from the floor as well as from online. So please welcome Mr. Nobuo Gohara. お願いします。
弁護士の郷原です。よろしくお願いいたします。日本の検察は控訴権を独占し、犯罪事実が認められても不起訴にする権限、訴追裁量権を持っており、その権限は強大です。日本の裁判所はこのように強大な権限を持つ検察の判断に依存する傾向が強く、検察が起訴した事件の有罪率は 99% を超え、検察の判断は事実上司法判断となっています。
The public prosecution authority in Japan, in fact, dominates that very prosecution authority. And even when the charges and the facts of a crime are acknowledged by the prosecution, they have the authority to drop the further prosecution. They have essentially discretion over all prosecution matters. This is a tremendously powerful right that they have. The Japanese courts, under this public prosecutor's office and powerful authority, tend to rely on that. And as a consequence, the conviction rate for the cases indicted by the public prosecutor's office, conviction rate is over 99% in this country. In effect, the decisions made by the public prosecutor's office are de facto judicial decisions.
検察に対する民主的統制を働かせるための制度として、検察が不起訴にした事件に対して、市民から無作為に選ばれた審査員が審査をする制度が検察審査会制度です。犯罪被害者、告訴人、告発人は検察の不起訴処分に対して審査を申し立てることができます。
There is a system to enable democratic control over the public prosecutor's office. This system consists of citizens randomly selected, appointed as committee members of an inquest committee, or the prosecution inquest committee it's called. And this is with regard to cases where the public prosecutor's office do not render an indictment. Victims, complainants, and accusers have the opportunity to file for an inquest against such public prosecutors' decisions of non-indictment.
以前は検察審査会が審査の結果、どのような議決をしても、検察が再捜査して再度不起訴処分を行えば、それで当該事件の刑事手続きが終了し、検察の不起訴処分が法的に覆されることはありませんでした。しかし、2009年に施行された検察審査会法改正で起訴議決制度が導入され、審査申し立てを受けて検察審査会が2回起訴すべきと議決をしたら、検察官ではなく、裁判所が選任する指定弁護士によって起訴手続きが取られるという制度が導入されました。
In the past, the prosecution inquest committee, no matter how they essentially voted on the results of their examination or inquest, the public prosecutors would embark on a re-investigation. And if they made another repeat decision to decline prosecution, the entire criminal procedure of such a case would terminate, and the non-indictment rendered by the public prosecutor's office would never actually be overturned legally. However, in the year 2009, the revised law, the revision to the Prosecutor's Inquest Committee Act, was promulgated and introduced a new indictment voting system, or a policy that would allow indictment resolutions to be made as follows. Upon filing for an inquest, if the inquest committee voted 2 times that the indictment should follow through, then the public prosecutor would no longer be the prosecutor. In fact, the court would then have the opportunity to select a nominated attorney to continue with the procedure to indict.
これまで検察審査会が起訴議決を行った事件の多くは、検察が嫌疑不十分、すなわち有罪を立証するに十分な証拠がないと判断したものでした。指定弁護士による起訴が行われても、最終的には無罪になる事件が大部分でした。
Up until now, the prosecution indictment committee's cases that were handled by this committee and actually made resolutions to vote to indict were considered, many of those such cases that they handled had been under essentially what the public prosecutor's office considered a lack of suspicion or a lack of evidence. In essence, not enough evidence to prove for a conviction.
しかし、
すいません。So that meant that even if an indictment was rendered by an appointed attorney, ultimately the cases were predominantly, in fact, almost all of them resulted in acquittals.
しかし、昨年5月に発覚した元東京高検検事長の黒川博氏の賭け麻雀による賭博事件では、検察が犯罪事実を認めた上で起訴猶予処分をしたのに対して、審査申し立てが行われ、検察審査会は、その年の12月に起訴相当議決を出しました。検察は1回の起訴相当議決を受けて、再捜査し、略式命令、これは書面審理によって罰金刑を言い渡す手続きです、を請求しました。
However, last year in May, an incident came to light. The former, at this time it's former, the former chief of the Tokyo High Public Prosecutor's Office, Mr. Hiromu Kurokawa, was alleged to have engaged in gambling with mahjong. The Public Prosecutor's Office acknowledged the facts surrounding these charges, but rendered a suspended indictment. Subsequently, an inquest filing was made, and the prosecution inquest committee in December last year issued that a decision. They voted that an indictment was appropriate. After this first time where an indictment was voted on, the public prosecutors made a reinvestigation and essentially demanded a summary judgment in the form of a document-based examination, excuse me, and as a consequence resulting in a fine.
それに続いて、今回、菅原一秀元経産大臣の公選法違反、違法寄付の事件について、検察が起訴猶予処分にしたのに対して、検察審査会が起訴相当議決を出し、検察は再捜査した結果、略式請求をしました。
In a continuing pattern, on this recent occasion, we have a case with respect to the former Minister of Economy, Industry and Trade, Mr. Ishu Sugawara. His case of offenses against the public office's election law, illegal donations, the public prosecutor's office rendered a suspended indictment. However, the prosecution inquest committee, upon receiving its instructions, issued a vote that deemed that indictment was appropriate. The public prosecutor's office then investigated and issued a summary order.
この事件は、菅原氏が経産大臣在任中の2019年10月に選挙区内での有権者への違法な寄付を行っていたことが週刊誌で報じられ、市民らが菅原氏を公選法違反で告発、検察は捜査しましたが、2020年6月に不起訴、起訴猶予としたものです。その際、不起訴処分の直前に、告発状を告発人に対して返礼し、告発人と認めないとすることで、検察審査会への申し立てが行われないように画策をしました。しかし、私が告発人から検察審査会への審査申し立てを受任し、検察が不当に告発状を返礼しても、正当に告発を行った者には審査申し立てが可能だとして申し立てを行った結果、申し立てが受理されました。
And this case involves Mr. Sugahara while he was Minister of the Economy, Trade and Industry in October 2019. Weekly Magazine essentially reported that he had been engaged in illegal donations to his constituency and of his voting district. Citizens accused him of violating the public office elections law, which prohibits donating within your voting districts. The public prosecutor's office made their examination, but in June 2020 came back with the decision not to indict, to suspend indictment of Mr. Sugawara. At that time, the public prosecutors also, immediately before rendering this decision not to file charges, that is, not to indict, they returned essentially the filing of the accuser, the official charges that were filed by the accuser were returned, and in that act they attempted to disavow that there was anybody accusing in the first place. This was essentially a device or artifice that was devised apparently so that a filing could not therefore subsequently be made to the prosecution inquest committee. At that time, however, I, on behalf of the accuser, received the power to make that filing to the inquest committee. And I alleged that even if this, essentially the accuser's official complaint was unreasonably returned by the public prosecutors, if there was an individual had properly made those accusations, it should be possible also to file for an inquest. Based on this reasoning, I made the filing for the inquest, and it was accepted.
検察は不起訴記録の提出を拒否するなど、検察審査会の審査を妨害しましたが、申し立て代理人、私が菅原氏の指示で違法な寄付を実行させられていた元秘書2名の陳述書、資料などを提出して、菅原氏の違法行為の規模、悪質性を明らかにした結果、検察審査会は審査会として独自に判断して、職権審査で起訴相当議決を出しました。議決書では、告発状編で不起訴記録提出拒否等についても、検察の対応を疑問視しています。
The public prosecutor's office refused to submit their records relating to their decision not to indict. They hampered the investigation of they hampered the inquest of the inquest committee, in fact, and the counsel of the complainant, the accuser, subsequently supported matters by, for instance, providing affidavits of the two former secretaries who had been forced to make these illegal donations under the direction of Mr. Sugawara, as well as clarifying how much the scale and the essentially the degree to how degree of malfeasance on the part of Mr. Sugawara's acts were. The prosecution inquest committee was able to render its own decision. They actually voted on the basis of their ex officio, their official capacity. The resolution was to indict. In their resolution, they also questioned the way that the public prosecutors had responded in this case. For example, their act of returning the formal filing of the accusation, and also refusing to submit the records regarding their decision not to indict.
2020年6月に検察が菅原氏を不起訴処分にした、この処分自体が極めて不当なものでした。この際認定した事実は、2017年から19年にかけて、香典枕花合計30万円を渡したという公選法違反事件でしたが、不起訴の理由について、東京地検は、香典の代理持参はあくまで例外であり、大半は本人が聴聞した際に渡していた。2番目に法を軽視する姿勢が顕著とまでは言い難かったと説明しました。 葬儀が年間90件あり、自身は8、9割出席しているが、他の要件で行けない場合にだけ秘書に香典を持参させていたという菅原氏の供述をそのまま採用し、葬儀に参列できない事情があった場合だけを犯罪リストとして捉えたから、このような少ない金額になったものと考えられます。
Essentially, this decision not to indict on the public prosecutor's office side with respect to Mr. Sugawara was quite unreasonable, despite the facts that had been acknowledged in June 2020. Between the years 2017 and 2019, the amount of funeral wreaths and other incense money that had been essentially distributed and or effectively gifted was around 300,000 yen in violation of the public office elections law. And the Tokyo District Public Prosecutors noted their reasoning for not to indict. Because the public prosecutors indicated that it was very infrequent that somebody was bringing such incense money, for example, on behalf of the Diet member, for the bulk of these funeral occasions. Mr. Sugawara himself visited in person to express his sympathies. And therefore, it did not indicate that he had been flouting the law to a large degree. It was not such a serious matter. And that with the number of funerals he was attending, he was in person 80 to 90% of the time. And essentially taking on what Mr. Sugawara said in his statement, verbatim, that it was only in the cases when he could not go to the funeral in person that he had his secretaries deliver. So in other words, this is why I think the amount of money that was involved was much less in the public prosecutor's eye, because they only essentially counted the amount that was taken on behalf of Mr. Sugawara by the secretaries.
しかし、2人の秘書の話では、2人の秘書は検察官に、香典と枕花の総額は年間おおむね100万円程度だったと、客観的な資料に基づいて供述しており、このような検察の認定が間違っていたことは明らかです。つまり、香典枕花名目で、選挙区内で金銭をばらまいていたのに過ぎなかった。法軽視の姿勢は顕著だった。それなのに検察は不起訴にしていたものであり、明らかに不当な処分でした。
The two secretaries, however, indicated by using and drawing on objective evidence of documents that the actual total annual amount of incense money and funeral wreaths were around 1 million yen. And they explained this to the public prosecutors. And that in fact, the public prosecutor's office had made a mistake in terms of the scale of the amount of money that was being essentially wafted around into his constituency. He was just spreading the money, essentially. And he was clearly being very much ignoring the law to a much higher degree than what was apparently thought by the public prosecutors.
今回の事件の意義ですが、検察が強大な権限に基づいて、現職国会議員の公選法違反事件を不起訴にし、検察審査会の議決を免れるための工作まで行った事件で、市民の代表である検察審査会が、検察の不起訴処分や対応にノーを突きつけ、検察の不起訴処分が覆されたというのは、画期的なことだったと思います。
Indeed, this whole matter was an unreasonable situation of handing a decision of not to indict. The significance of the case at hand here is that matters have been overturned. based on their enormous authority, the public prosecutors decided initially to not indict a sitting Diet member for violations of the Public Elections Office law. And they even went to the extent of coming up with a device to try to avoid the decision rendered by the Public Prosecution Inquest Committee. The citizens of this inquest committee, they said no to this decision to not indict and to no to the way that the Public Prosecutor's Office decided to address the matter. This was quite a breakthrough for such a decision not to indict by the public prosecutors to be overturned.
カルロス・ゴーン氏の事件でも海外から注目された人質司法も、検察が絶大な権限を持ち、刑事司法の正義を独占していることに根本的な原因があります。検察の訴追裁量権の行使の不当性が検察審査会によって明らかにされ、検察が独占する刑事司法の正義の一角が崩されたことが、日本の刑事司法の抜本的な改革の契機になることが期待されます。
Even in the case of Carlos Ghosn, where hostage justice become quite the topic around the world, the public prosecutor's office shows that they have an absolute authority and are actually have a monopoly on what they consider justice within this criminal justice system. There is a root cause to this problem and problems we see. This unreasonable exercise of the discretionary authority to indict by the public prosecutors has come to light again through the Prosecution Inquest Committee. And we see that the justice that we need to see against the criminal justice system that is being completely dominated by the public prosecutors is now having some effect of change. And we are looking forward for this as another timing where we may see some overhaul to the criminal justice system in Japan.
まもなく出される予定の菅原氏の略式命令の注目点ですが、公選法違反で罰金刑に処せられると、原則5年間公民権停止、選挙権、被選挙権が停止されます。これは情状によって短縮できます。検察は公民権停止期間も含め、略式請求での求刑について明らかにしていません。略式命令が3年に短縮されると、菅原氏は次の衆議院選挙に立候補可能となります。このような事件で、裁判所がどのような判断を出すかが注目されます。
With respect to the summary judgment against Mr. Sugawara that will be issued soon, we note that the punishment or the penalty essentially for violating the public office elections law is that you are suspended from any of your rights as a citizen for 5 years in principle. That is, you don't get to vote and you don't get to stand for election. However, this 5 years can be reduced in period of time according to circumstances and the impressions of the person involved. Public prosecutors have not made known what they intend to demand in their judgment, demand judgment for, including the amount of time that the rights, citizen rights would be suspended for Mr. Sugawara. If, for instance, this was going to be only an order for 3 years, Mr. Sugawara would then be able to stand for office again in the elections 2 times out from today. So we do look forward to see what the court will decide in this case. It is noteworthy.
Okay, thank you, Mr. Gohara. And then we have Muraiso, Mr. Muraiso. Go ahead.
私は2018年12月から2020年3月まで菅原氏の秘書を3年3ヶ月やっておりました。
I was Mr. Sugawara's secretary for 3 years and 3 months, from December 2018 until March 2020.
約3年間、菅原氏の秘書として懸命にやってきましたが、その間、数々の違法行為を強要させられてきました。菅原事務所は菅原氏の言うことは絶対の事務所で、菅原氏の指示で違法行為が常態化していました。
I worked very hard as Sugawara's secretary for about 3 years. And in the course of that, I was subjected to being forced to engage in a number of unlawful activities. Sugawara's headquarters is where Sugawara's word is absolute. And under his direction, it became everyday practice to engage in unlawful activity.
2018年10月に週刊誌報道で秘書が香典を差し出して写真の記事が出て、菅原氏は経済産業大臣辞任に追い込まれました。その後2ヶ月間病気で休んでいると嘘を言って、国会にも公の場にも出ることはなかったのですが、その間裏では週刊誌に香典を渡す写真を撮られた秘書 A 秘書が週刊誌とつながっていて、写真を撮らせた秘書にはめられたなどとありもしないことを各講演会関係者や支援者に言い回ったりしてました。A 秘書と A 秘書の仲間だと思われていた私は、事務所に入ることもできないようにされ、仕事も与えられないというひどい仕打ちを受けてきました。
In October 2018, there was a photo published in a weekly magazine reporting that a secretary had furnished incense money at a funeral. And this being on behalf of Mr. Sugawara, he was subsequently forced to resign as Minister of Economy, Trade, and Industry. 2 months since that time, he falsely stated that he was convalescing from illness and failed to appear in any public matter and did not come to the diet. But during that time, in the background, he was going around to the supporting organizations and talking to the associates and supporters of his constituency, saying that the weekly magazine and that secretary, that is so-called Secretary Letter A, they're in cahoots. They had that photo opportunity set up, and I was essentially framed by my secretary. Complete falsehoods were being spoken by this man, and myself considered to be somebody who was a friend of Secretary A, and Secretary A also were prohibited from actually doing their job at the headquarters of Sugawara's office, and essentially given no work to do, being treated extremely horribly.
去年11月頃から検察庁で何十回も取り調べを受けて、菅原氏の指示で地元の人が亡くなった時に香典を持って行ったり、枕花を手配したりしていたことについて詳しく話しましたし、それ以外にも会費や祝儀などのお金を出すことが常態化したことも話しました。それにもかかわらず、去年の6月、菅原氏は不起訴処分になったと聞き、信じられませんでした。自分が検事に話して調書に取られた香典枕花の件だけでも1年で30万円を超えていました。3年分で30万などという少ない金額のはずがないと思いました。また大臣を辞めてからといって許されるものかと感じました。その後、
すみません。So 2 Novembers ago, I sat down with the public prosecutor's office and began a series that ended up to be dozens of occasions of investigation on their part, and talked in detail about how, under the direction of Mr. Sugawara, if local citizens passed away, incense money would be taken by me, or I would be arranging for funeral wreaths. Also, what has become an everyday practice was to provide monetary gifts and pay for memberships. I talked about and explained all of this to the prosecutors. Despite this, I could hardly believe it when I heard that he had essentially been given no indictment, and that decision had been reached last year in June. All of the amounts that I talked about to the public prosecutor personally, and which were essentially recorded by the prosecutors, had exceeded 300,000 yen in 1 year. So it couldn't possibly be such a small amount, such as 300,000 yen for 3 years. And I really don't see how he could have been forgiven just by resigning from his post as minister.
その後、今年の3月頃に検察審査会が起訴相当の議決を出し、検察で起訴になりました。菅原氏は起訴になる前に議員辞職し、その際、刑事処分がまだと言って説明を拒否しましたが、起訴されても何の説明もしていません。刑事処分が決まったら、これまで多くの違法行為を行ってきたことについて説明を果たしていただきたいと思っております。
Then later, that would be March this year, the prosecution inquest committee voted and reached a decision for indictment. The public prosecutors subsequently decided to indict him. Mr. Sugawara resigned from his position as Diet member before the indictment, and he refused to describe anything related to this matter because he said that there was no decision rendered by the criminal justice system. However, he has still not talked about this at all, even after the indictment was issued. Once the final decision is made as far as his criminal disposition in his case is made, I would really believe that he needs to start to be accountable for all of these many activities that were unlawful.
香典枕花、さまざまなお祭りや町会や団体などの会合での寄付公費、お歳暮、お中元などの配り物など、選挙区の人に対してお金を出したことは報道されているとおりです。菅原氏に指示されて実行されている秘書の私たちの目からしても、すべて自分の選挙で投票してもらうためにお金を配ったことは明らかでした。
The funeral wreath, the incense money, the myriad donations to all of these festivals, local neighborhood associations and organizations, the gifts at the end of the year, the middle of the year, everything that has been covered in the media regarding his expenditures to his voting district are exactly as reported. Even for us as secretaries, from our perspective, and doing these acts as ordered by Mr. Sugawara, it was very clear that he was essentially handing out money in order to get the people to vote for him in his election.
菅原氏が指示する違法行為はそれ以外にありました。野党候補のポスターを剥がしてこいと指示されて剥がしてきたこともありました。地元の会合での葬儀、通夜の情報を取り損ねると罰金を要求されていました。被災地に現地視察に行くと言って事務所のメンバーを引き連れて行って実際にはゴルフなど視察とは何にも関係ないことをして楽しんでいたこともありました。被災地の人のことを何とも思っていないですし、このような人が政治家をやってもいいのかと疑問に思うことばかりやっていました。
There were other things that Mr. Sugawara ordered that were unlawful activities. I had to go remove a poster of an opposition candidate once when he ordered that be done by me. If I failed to get the information regarding meetings, funerals, and other wakes that were being held locally, he fined me. He said that he was going to go on a visit to an area that had suffered a natural disaster and to essentially visit locally and he would take his members, people from the office with him. But they actually didn't go there to do any official visit. They played golf and were enjoying themselves, doing nothing to do with attending to such a disaster. He apparently has no feelings for the people who have suffered. I really, truly started to question why this person would be fit to be a politician.
私たち秘書が菅原氏に対して違法なことをやめるように言ったことは何度かありましたが、それを聞き入れずに何度も違法な行為を強要させられてきました。菅原氏自身はやっていけない行為だと思いながらやっていたのは明らかです。10年ほど前にもカニ、メロンを選挙区内で配っているという報道をされたにもかかわらず、その後もやり続けていました。反省しているには程遠いことばかり繰り返していました。事件発覚後も事務所の資料などをシュレッダーにかけて証拠隠滅をしたりしていました。
The secretaries, including myself, made several occasions to tell Mr. Sugawara to stop his unlawful actions. He did not listen, and we were forced to repeatedly engage in this unlawful conduct. Mr. Sugawara himself, it's clear that he knew that this was activity that was not supposed to be done. About 10 years ago, there was news coverage of him distributing crabs and melons to his constituency. But he continued. He kept repeating things. He was far from regretting his actions. He was also hiding evidence by shredding documents after the incidents occurred at his office.
3年間秘書として菅原氏のためにやってきましたが、その間さまざまな違法行為を強要させられたり、罰金を取られたり、数々の仕打ちを受けてきました。それを秘書が勝手にやったことだと言い続けてきたことも含めて、すべて真実を伝えた上で謝罪をしてほしい気持ちでいっぱいです。
For 3 years, I have been engaged on behalf of Mr. Sugawara as his secretary. During that time, I had been forced to engage in unlawful activity. I was fined. And there were many instances of retribution. And he kept saying that it was the secretary who did it on his own. All of this, I think, we need to understand now that the facts have to be made known. And I personally feel that I would have an apology.
Okay. Thank you very much, Mr. Muraiso. So we're going to go to Q&A. If there's any questions from the floor, we take them first. And if there are any questions coming in online, we'll go to that. And please raise your hand. And if you're designated, please come forward. There are 2 microphones at the both end of the front desk. So please come up and cite your name and affiliation. And please only ask questions without making a statement. Who will go first? Okay.
フランス店の及川と申します。秘書だった方に伺いたいんですが、菅原一秀さんというと、何人かのジャーナリストが、統一教会との関係、密接な関係を追っていらっしゃって、記事にしていますが、実際のところ、統一教会とはどのような関係だったのか、もしご存知でしたら教えてください。
はい、すいません。詳しくは存じ上げないので、わからないです。
はい。Should I interpret the question and the answer?
Please.
The question from France TV is that some time ago there was coverage about a strong connection between Ishu Sugawara and the Unification Church. Are you aware of this matter? The answer is I don't know those details.
Okay, next question. Anyone? じゃあ山田さんどうぞ。
郷原さんと、村潮さんに一つずつお伺いしたいんですけど、今回、起訴をしなかったことに対して、検察審査会が動いて、それで略式起訴、非常に形式的かもしれませんが、一応それが覆ったということがあります。ささやかな一歩だと思うんですが、こうした政治家絡みのいろいろ犯罪といいますか、違法行為について、日本の検察は非常に甘いと思うんですけれども、この一歩がこれからどのように広がっていく可能性があるとお考えでしょうか。例えば安倍首相の問題もありますが、桜を見る会、なかなかハードルは高いと思うんですが、動いていくのか、それともまだなかなかそこまで、動かないのか、それを動かすとしたら何がこれからの大事な要素になるのかということを伺いたいと思います。それから村長さんには違法行為を繰り返したことに対して秘書らから、こういうことやめてくださいと言ったけども言うことを聞かなかったという話がありました。もう少しそれはその時の状況とか、どんなような時にどういうふうな表現をしてどんなふうに断られたのかというケースが一つでもあったら、そのことについて話してください。以上2点です。
質問先にします。
質問お願いします。
So two questions, one for Mr. Gohara and one for Mr. Muraiso. First question for Mr. Gohara. With this situation where the public prosecutors decided not to indict being overturned with essentially a summary indictment that happened, in a way it's kind of a formality, and it's a small step of admitting that a correction was necessary. How do you, however, look at this? The crimes committed by politicians seem to be treated very lightly by the public prosecutors. How do you think this is going to change? For example, the cherry blossom viewing party incident with regard to former Prime Minister Abe comes to mind. Will things move forward in a positive fashion or not? And how do you foresee things changing?
今回の菅原氏の事件というのは、先ほどお話ししたようにですね、明らかに起訴すべき事件で、当初から、全く不当な不起訴処分、起訴猶予処分でした。で、それを検察は、検察審査会に持ち込まれないように、告発状を返礼するというような工作までやった。で、それが検察審査会で覆されたというところに非常に大きな意味があります。これはもう検察は起訴猶予にする、検察が起訴猶予にする処分を本当に信頼していいのか、信用していいのかというような問題でもあると思います。検察が、強大な絶大な権限を持っている検察がこういうような不当な処分をするということを皆が認識して、国民全体が検察の権限行使をしっかり監視していかないといけないんじゃないか、それをしっかり行っていくことが今後ですね、他の事件でも不当な不起訴をなんとか市民がさせないようにするということにつながるんじゃないかと思います。
As I've described, this case with Mr. Sugawara was was quite clear cut. The public prosecutors should have rendered an indictment. It was completely unreasonable. And then they proceeded to come up with an artifice where they were going to return the formal complaint such that that would take away the ability, ostensibly, to have this prosecution inquest committee make a follow-on decision. So it begs the question, can we really trust the public prosecutors when they decide to suspend an indictment? They have such absolute powerful authority. The citizens of this nation must monitor the public prosecutors closely. They need to watch other cases to prevent them from feeling like they can issue these unreasonable non-indictment decisions.
その具体的なエピソードということで、 当時、菅原氏が経済産業大臣になったときに、胡蝶蘭というお祝いの花が送られて、事務所に送られてきているんですけども、その花を菅原氏が後援会のところに持っていけという指示がありました。で、大臣にもなったし、そういう表にかなり影響がある人っていうのもあって、秘書たちは私たち秘書は菅原氏に対して持っていくのは良くないんじゃないかということを伝えたところ、菅原氏はじゃあ置いてこいということで、言い方を変えただけで、ただ秘書の秘書の言うことを耳に傾けることはなかったです。
So with respect to a specific incident where Mr. Sugawara didn't listen to the secretaries saying that the activity contemplated was unlawful, how did he behave, or how did he refuse to listen? And the answer to that question is one incident that I recall is when Mr. Sugawara actually was appointed the Minister of Economy, Trade and Industry. He received orchids as essentially a congratulatory offer. They were delivered to his headquarters. And he told us, the secretaries, to, quote, take the orchids to his supporting organization. We responded by saying, we don't think that's a good idea, Minister. But he, being now much more influential and now a minister, replied and said, well, if you can't take the orchids, leave the orchids at the place. So all he did was change his phrasing, but he really wasn't listening to us.
I don't know if I have properly introduced Mr. Gohara, but he is the one who complained to the prosecution inquest committee. 郷原弁護士がそもそも検察審査会への申し立てをした申し立て人が、郷原さんだったということをちょっと最初にきちんとご紹介してなかったかもしれませんので、改めてお伝えしておきます。他に質問ございますか？ Okay, while you guys think about some questions, I have some questions from front desk. でちょっと私の方から郷原さんと村瀬さん、まず1点なんですけれども、検察が明らかにその秘書の方々が言った中身よりも軽い罪で略式起訴という形をした、そもそも最初は起訴もしていなかったということですよね。で検察が非常に問題であるというご指摘は分かったんですが、そもそもなぜ検察はそのようなことをするのか、あるいはするメリットがあるのか。つまり本来検察は政治家のこれ言ってしまえばもうその汚職の一種ですからね、その買収ですから喜んで起訴してもおかしくないような話だと思うんですが、なぜあえてそれを軽くしているのか。それはもちろん検察に聞かなきゃいけないことですが、ちょっとそこのところがなかなかちょっと合理的な説明が今のところはないというのが1点目です。それから最初全部言っちゃうかな。それからもう一つなんですけども、村磯さんは菅原議員からのいろいろなどこどこにお金を持ってけという指示とかですね、そういったものはメールや LINE やそういった実際に証拠に残る形で受け取っていたというふうに伺ったんですけど、それも検察に出してるわけですね。つまりただ村磯さんや他の人の方が検察にただこう言ったと、で菅原さんはそうじゃないと言ってるっていう話じゃなくて、そもそももう物が、その証拠を裏付ける物が提出されてるわけですよね。なのに検察は、おそらく数百万円分は証拠としてあったにもかかわらず、 最終的には3年間で、80万
最初は30万。
最初30万で最終的に80万になったんでしたっけ、明らかに極端に小さい金額にしていると。なので、やはりそこがなぜそのような証拠もあって物まで出していて、なぜあえてそこまで小さくしようという動機が働くのかが、仮説になってしまうかもしれませんが、よかったら教えてください。
So first question is, we see that the public prosecutors have rendered their decision essentially counting up a crime that's much lighter than what the secretaries alleged. So the question is why did they do that? And why are they doing this type of thing with regard to this kind of case? Because corruption would be something you would think the public prosecutors would be delighted to prosecute to the full extent of the law. Well, we should ask them this, but we ask you, Mr. Gohara, if you could perhaps shed light on this. And also, to Mr. Muraiso, we wanted to ask about Mr. Sugawara, if he perhaps sent emails or line text messages regarding his directions on sending these monetary gifts out. If this evidence was also submitted to the public prosecutors, and it wasn't just simply providing statements to the prosecutors, because they came back, the public prosecutors came back with 300,000 yen over 3 years, which was much less than the actual amount. And so I'm just wondering why, despite all of the physical evidence, they would behave this way. And perhaps the question would have you lead to some conjecture, but if any light could be shed on that, it would be helpful.
なぜ検察がこのように事件を、軽い方に、事実を小さい方に認定をして軽い処分にしようとするのか、これはもう正確なところは分かりませんけども、おそらく検察としては現職の国会議員を、失職に追い込む、あるいは辞任に追い込む以上は、やはり何か重大な事件で自分たちがかっこよく検察を国会議員を断罪できるような事件でやりたいという、一つのプライドのようなものがある可能性があります。ですから公選法の有権者への寄付程度ではやりたくない、検察の一つのメンツのようなものかもしれません。しかし法律に有権者への寄付を行った、それが認定されたら公民権停止ということがちゃんと定められているわけですから、検察はそれを淡々と起訴して罰則を適用すべきだと思います。検察のそういう自分たちの格好とかメンツにこだわるやり方が逆にその金を使って選挙をやる、有権者の関心を買うというようなやり方をはびこらせることになっているんだと思います。
I'm not absolutely sure why the public prosecutors tend to want to make light of such criminal conduct in these instances. But perhaps there's something related to the public prosecutors in terms of their pride or their form, the form that they wish to take. If in the event of having to force a sitting Diet member to resign from his post, they would want a real serious case that they can bring out. And they also want to do it of their own volition to make it appear that they have really got a bad one. So they seem to be not interested at the level of violations like public office elections. Yet it's clear that it's unlawful to make these donations to citizens, and that you lose your rights essentially as a citizen if you violate this law. And I think it's really the public prosecutors need to just get into the mode of issuing what they should whenever illegal activity is clearly found, and they need to follow through according to the letter of the law.
すみません、今のはじゃあ郷原さんだけで結構なんですけど、ただやっぱりどうしてもお伺いしたいのは、実際に検察から取り調べをね、受けられたわけですよね。でその時に果たしてその検察はどうだったのか、つまり普通はですね、もう洗いざらい全部出せっていうふうに厳しい取り調べがないとおかしいような事件だと思うんですが、最終的には出したもののほんの何分の1しか起訴しないわけですから、そもそも取り調べの段階から何か感じられるところはあったかどうか、もし村井さんの方であればお願いします。
はい。じゃあ質問を訳しましょう。
お願いします。
So just to follow on, Mr. Muraiso, you were actually investigated by the public prosecutors amidst all of this. You would think that they would normally be very tough on you, to make sure that you let them know everything, have all the evidence set forth and put on the table. Yet they only returned their decision based on a fraction of what you apparently had provided. So maybe you could tell us what actually happened, how they behaved, and how you had to respond to them in the investigation.
はい、やっぱり最初の方は LINE とか、あと Google アカウント、それ以外にも菅原氏に関する資料などをすべて検察の方に提供しました。でその上で香典枕花以外にも寄付行為に関することについて話を聞かれることばかりでした。でもだんだん徐々に菅原氏の不起訴の処分に近づくにつれて、やっぱり香典枕花に絞ったことしか聞かれなかったなっていう印象はありました。以上です。
Well, initially, there were the line text messaging, the Google account, and then all kinds of documents associated with Mr. Sugawara that I produced. There was a lot of questioning about the donations, in addition to the incense money and the funeral wreaths, but it seems in my mind as they got closer and closer to their decision not to indict, they started to become more and more focused on just the incense money and the wreaths.
Okay. There's one more. じゃあどうぞ。じゃあ this is going to be the last question. ちょっと5分過ぎましたけど大丈夫ですか。
フリーの竹内と申します。この案内文の方ですね、こちらの方では、1年にですね、数百万円に上るというようなその金額が書いてあるんですけど、実際のところはご自身で大体体感したところでいくらぐらい動かしてたのかなというのと、あとすみません、もう一つ、こういう人っていうのは、嫌がることをやらせるためにパワハラ等の行為があったんじゃないかなと私は推測するんですが、そういったことは感じましたか。この2点です。
はい。I interpret the questions, Ms. Takeuchi, freelance. I received the information in advance of this press conference. It was and the amount of money being essentially handed out was characterized as a few million yen every year. Just from your perspective, Mr. Muraiso, how much money do you think we're talking about? What was the feeling you have in terms of the scale and size? And secondly, when you have a situation like this, I tend to think about power harassment as a theme, because when you have somebody who is essentially forcing things on another person, could you talk about that?
3年分で数百万だと思います。1年で数百万って話は出てないと思います。はい、
So first question answer is I think it's a few million yen across 3 years, not 1 year.
Okay, and Mr. パワハラのこと先に言う。はいはい、どうぞ。はい。
菅原氏からのパワハラについては、やはり催しとか、そういった会合だったり、そういったことの予定を取りこぼしたりすると、やっぱり取りこぼしかといって罰金を払えとか、取りこぼしだとか、またバカだ、アホだとか、そういった暴言も吐かれたこともありました。で、そういった罰金も菅原氏から指示されることもあったり、その罰金を払うことも多々ありました。以上です。
With regard to power harassment from Mr. Sugawara, I guess I would have to say that if I had neglected somehow to report back to him about events or assemblies that were happening locally, he would say, "Oh, so you forgot to find out about this again. You have to pay a fine for making that mistake," or he would even call me an idiot at times. So that's sort of what I experienced.
いいですか? Okay. All right. So this will be it. And Mr. Muraiso wishes to make the last statement. He just wants to add one last statement. So, Mr. Muraiso, go ahead.
はい。別の秘書から聞いた話なんですけども、今でもなお秘書にはめられた秘書が週刊誌からお金をもらって香典を渡している写真を撮らせたと各所に言い回っているそうです。その大臣辞任後の時もそうでしたが、まるで自分がはめられた被害者のように説明をしているということを本当に全く反省していないなと思っておりますし、腹立たしく思っております。本当に反省しない、もう言葉は悪くなってしまうんですけど、野郎だなという思いでいっぱいです。以上です。
I wanted to let you know about something I heard from another secretary recently. Apparently, Mr. Sugawara is still going around saying that he was framed by his secretary, and that the secretary had received money from the weekly magazine in order to hand the incense money over in a staged photo. And continues to apparently go around telling this story at various places. So it continues to play the victim that he was somehow railroaded into this. It angers me tremendously. He refuses to show any remorse. He won't. He refuses to admit anything here. It just makes him. It just makes me so angry, and I just think that he's just a horrible person.
Okay, that's it. Thank you very much. And if you would interested in doing a story, I spoke to another secretary of Issue Sugawara, and he said he's happy to provide the evidence that he presented to the prosecutor, such as the copy of the exchange of line and emails as well. They might have to mask the certain, individual names, but they're happy to provide evidence to reporters as well. So if you're interested in doing a story and interested in getting them, もしコンタクトしたい場合、小原先生ですね、秘書の方にコンタクトしたい場合、please do contact Mr. Gohara for access to former Issue Sugawara secretaries. Okay, thank you very much for coming to the press conference, and bye-bye.